Good morning, students. Today we are going to discuss this recent controversial judgment which has been passed by Allahabad High Court. Now, the discussion should, in my opinion, we will discuss it in the context of what did the High Court say, and then how the Supreme Court has given its perspective and has, declared a stay on the particular uh, order that has been passed by the High Court. When we talk about the incident that has taken place, it has raised the question on when can an act be considered to be under the ambit of preparation and moves on to the context of it being something which can be called an attempt. And in this situation, it was an act of sexual violence that was involved, and therefore it incorporated the legislations of POCSO, and also Section 376 was levied under IPC. So, as we look into the case, we'll continue to discuss what are the different aspects that the High Court looked into, what was its perspective, and then what was the Supreme Court's response, and what was the Supreme Court's perspective towards the incident. So, when we start off, we'll talk about the incident that was involved and how and what then pursued after that particular incident, how it was dealt with. The incident is that there were three individuals involved in the case, that is Pavan, Akash, and Ashok. They were on their way, and on the way, they met this particular lady who was along carrying along with her daughter, a minor daughter. They offered to take the minor daughter to her home as they were co-villagers. And this mother agrees and allows the daughter to be pillioned along with the accused. Now, in the middle of the way, these accused stop and they start touching. Especially in this situation, it was Akash, the accused, who touches the breast of the daughter and then pulls on the string of her pajama and is dragging her down towards the culvert. This is the basic fact, and at that particular time there were certain witnesses who see, and they come in, and the accused threaten these individuals that there will be dire consequences if they make any statements, and they even show a pistol towards these witnesses and they flee the scene. So in short, it means that they give a lift to this girl and then they stop on the way. One of the accused has touched her breast and has pulled on the string of the pajama and is pulling her down towards a culvert, at which point these witnesses are present and then the accused flee. In context of this, we see that the special judge, he basically brought in the context of the charge that they wanted to frame in relation to section 376 along with POCSO section 18. Now, debates begin on whether this would be the appropriate charge, and on that debate, this incident is then basically dealt with in major detail by the High Court. It states that, and then we go directly towards the paragraphs which have been actually highlighted also by the Supreme Court as some things which they didn't consider to be suitable interpretations. Before that, what is section 18 of POCSO? It is the punishment for the attempt to commit an offense. Now, whoever commits an offense or any offense punishable under the Act, or to cause such an offense to be committed, and in such attempt does any act towards the commission of the offense, shall be punished with imprisonment of any description provided for the offense. So, Section 18 has been levied in the against these accused, along with 376. And furthermore, section 7 and 8 has also been highlighted by the High Court, state talking about and defining sexual assault, where they say that where anyone touches the vagina, penis, anus, or breast of the child and makes the child touch the vagina, penis, or anus or breast of such person or any other person, or does any other act with sexual intent which involves physical contact, will be liable under the provision. And section 8 provides punishment for the same. Now, When we go towards finally, according to what the lower court or the Boxer court had special court had mentioned, it stated that, and the High Court has analyzed this and stated that 376 and 511 were not applicable. Rather, the 376 along with section 18 for attempt was applicable on the particular case. Therefore, the lower court had found that in this case it was an attempt to rape or an attempt to commit penetrative sexual assault within the purview of POXO. Now the High Court realigns itself and talks about 354 clause B, which is the offense, which is punishment which relates to an assault or use of criminal force against any woman with the intent to disrobe, which shall not be less than 3 years, but which may extend to 7 years and shall also be liable to fine. Further, it states that 354 of IPC provides punishment for assault of criminal force to women with intent to outrage her modesty. So these are two provisions which the High Court has not now highlighted, apart from the ones which were originally put in by the POXO court. This case, then, the court reiterates the fact that Pavan and Akash grabbed the breast of the victim. Akash tried to bring down or lower the garment of this victim, and for this purpose had broken the string of her garments and was dragging her beneath the culvert. But an intervention was there of witnesses which left the victim and they which led to them leaving the victim, and they fled from the scene. Now, this is where the important part of the para begins. They say that it is not sufficient to draw an inference. This set of information is not sufficient to draw an inference that the accused persons had determined to commit rape on victim. As apart from these facts, no other act is attributed to them further their alleged desire to commit rape on the victim. Now we must discuss this part, and this is where the discussion on stages begins. Whether an act comes under the ambit of preparation or under the umbrella of an attempt is something, when we talk about the different principles which are applied to this particular discussion, there are so many aspects which come into picture. An attempt is related to the fact that how proximate it is to the actual commission of the crime. Maybe not in all situations, but it does help us understand whether the act was an attempt. Also, it must be of such clarity that it gives us no doubt in our minds that the person is going to commit the act. So in this situation, the perspective, or bearing in mind the different the rules of interpretation of attempt or the principles involved in understanding the concept of attempt, the court is trying to tell us that are we at this stage, when these accused have been stopped by witnesses, having enough information to be completely sure that they were going to commit rape? Because there are a gamut of offenses which can be committed, which align with sexual violence and violation of the sexual rights of an individual, of a minor. Are we completely sure that they were going to commit rape? Are the facts sufficient enough for us to attribute that the individual is going to commit rape? In context of defining whether an act was preparation or attempt, there is also the concept, there is also this uh, perspective that attempt is a situation where you do not have an opportunity to withdraw. Preparation is a time when you can look into things and decide whether you do not want to commit the crime. And there is a famous example that is given wherein a woman is running towards a well, and when she stops before she jumps, and it was not considered to be attempt because there was opportunity for her to withdraw from the situation. So there are these different rules of understanding the concept of attempt and defining and differentiating it from preparation. At this point, when they are pulling her down, of course, there have been wrongful things which have already been done to her. Can we, with all clarity, say that it was and they were 100% going to commit rape? That is what this half or this line tends to explain to us, or that is what can be inferred by what the High Court is trying to say. So, repeating myself, the court is saying, is the fact sufficient to draw an inference that the accused persons had determined to commit rape on victim? As apart from these facts, there is nothing else that we have. We then come to para 23. It states that there is no allegation in the complaint or in the statement of the witnesses recorded that the accused Akash himself got unrest after breaking the string of lower garment of the minor victim. The specific allegation against Akash is that he tried to drag the victim beneath the culvert and broke the string of the pajami. It also stated, it is also not stated by the witness that due to this act of the accused, the victim got naked or undressed. There is no allegation that accused tried to commit penetrative sexual assault against the victim. So now again the High Court is re-highlighting that maybe it is trying to suggest to us what must or what aspects are relevant in case we are trying to establish attempt. At this stage, and by reading this para, what we understand is that he, Akash, may have pulled on the pajami, may have broken the string, but this point of debate is that he himself did not get naked. He himself did not get undressed. And there is no allegation against the accused that he tried to commit an act of penetrative sexual assault. So, on his side, for the commission of the crime, this, has he done any particular act? Has he undressed himself? Has he tried to commit penetrative sexual assault on the individual? These things are absent. This is what the High Court is trying to tell us. But this is also one thing which might lead to a debate in context of, are we going totally towards how, from the perspective of the accused, whether or not he's commissioner going to commit the crime or not. The other aspect is also, when there are sexual offenses involved, there is sexual violence involved, we have to look from the perspective of the victim and what the victim felt at that particular time or incident. So there, this whole contradiction or debate comes in, is the perspective leaning towards how the interpretation comes in from the side of the accused. But what about, what does the victim feel at the particular point in time, right? So this also does create a question, that is this really relevant to establish attempt, that there is some act of undressing on the side of the accused, or is there penetrate an act of trying to penetrate relevant when it comes to establishing attempt from the side of the accused for commission of rape. Now comes a provision, a para, which is again specifically declared by the Supreme Court as something which they were disappointed with, which states that the accusations which have been leveled against Pawan and Akash and the facts of the case hardly constitute the offense of attempt to rape in the case. In order to bring out a charge of attempt to rape, the prosecution must establish that it had gone beyond the stage of preparation. The difference between preparation and actual attempt to commit an offense consists chiefly in the greater degree of determination. So, basically, trying to tell us that at the stage of preparation, the degree of determination is weaker, but when it is attempt, it is a more determined act. It is an act which clearly signifies that you are moving towards the commission of the crime, that it leaves no doubt in your mind that you are going to commit a certain type of crime. Whereas here, according to the High Court, sufficient facts are not provided us for us to be clearly determined, or for it to be clearly determined that it is attempt. And this has been basically criticized by the Supreme Court. This is something which they have not taken or appreciated in the particular uh, decision, in the order that has been passed by the High Court. So they have basically not appreciated and highlighted para 21, as I said, where the use of the term determined, or the act, whether it determined the commission of rape, and whether the removal of garments of the accused was there or not, whether there was any allegation that he tried to commit penetrative violence on the female or not. That conversation began here. This was not appreciated by the Supreme Court. Then we come to 24, where the High Court has said that there has to be greater degree of determination when you want to establish attempt as compared to preparation. Now, the High Court referred to certain cases in context of this concept of degree of determination. It said that in the case of Rex versus Lloyd, in order to find the prisoner guilty of an assault with intent to commit a rape, you must be satisfied that the prisoner, when he laid hold of the prosecutrix, not only desired to gratify his passions upon her person, but that he intended to do so at all events, and notwithstanding any resistance on her part. So you have to establish these tenets. You have to establish that there was a complete intention, there was a complete desire to gratify passions. And in the second case, he states that we believe that in this country, indecent assaults are often magnified into attempts of rape, and even more often into rape itself. And we think that conviction of an attempt at rape ought not to be arrived at unless the court be satisfied that the conduct of the accused indicated a determination to gratify his passions, and at all events and in spite of all resistance. Now we have to remember the background of this case, where these individuals fled on seeing of the witness, and on the fact that we can't clearly state from the facts of the case that was how determined these individuals were to commit the crime, and the fact that there was additional, was there's an absence of facts which states that there was any additional facet which would help us clearly, without any doubt, establish that they were going to commit rape. This is the perspective from which the High Court comes from, that we must have complete determination that they intended to commit rape, whether there was resistance, whether anybody was stopping them, or the victim has been showing resistance on her part, and so on. So they are saying that we don't have enough facts to say that at that stage there was a determined act to commit rape on the individual. Now, the High Court goes on to say that after a thoughtful consideration and meticulous examination of the facts, the court has come to the conclusion and is of the opinion that Pavan and Akash grabbed the breasts of the victim, and Akash broke the string of her pajama and tried to drag her beneath the culvert, and in the meanwhile, on interference of passers by, the accused fled away. And this led to the victim being left behind. According to them, it is not sufficient to hold that a case of section 376 or 511 along with, or 376 along with section 18 of POCSO has been made out against the accused persons. In short, trying to say that the amount of information we have does not give us sufficient clarity that there is going to be an attempt to commit rape, that this is sufficient to make an allegation that there will be an attempt to rape the individual. Further, the court says on the facts of this case, a prima facie charge of attempt to rape is not made out against Pavan and Akash, and instead they are liable to be summoned for a minor charge of 354B, which is an assault or abuse of a woman with intent to disrobe her or compel her to be naked, and Section 9 of POCSO, which provides for punishment of aggravated sexual assault. Right? So now the court has reduced the charge to 354B along with Section 9 and 10 of POCSO, stating that they don't feel that the facts clearly determined the fact that it was attempt to rape. So, in conclusion, when we talk about this order of the High Court, what we understand is that the perspective of the judiciary of the High Court was that there is a distinction between preparation and attempt. In attempt, there is a lot of clarity from the actions of the accused that you are going to commit the offense. And here, the stage at which they are found, it's not clear to the court that it would clearly and definitely lead to the commission of rape, and therefore the use of the terminology of degree of determination and the idea that undressing of the accused, or that there was any attempt or any act of trying to penetrate against the minor was not made against the accused, and therefore to establish attempt to rape in this scenario, according to the High Court, was not possible. And now, lastly, coming to what the Supreme Court said, the Supreme Court said that there is an insensitivity in the decision. Especially now, when we have looked at the decision, when you have a look at the para 23, 24, 26 and 21, which we have already discussed, the court specifically highlighted those paras and said that there is a sense of an inhuman approach towards the minor, the kind of incident that has taken place, which has sexual overtones, sexual violence as overtones, sexual abuse as overtones. So you see that the Supreme Court wants to reiterate the perspective that this is sexual violence. It is against an individual who is a minor. The allegations are against a minor, a victim who is a minor, and that the perspective must come in from the side of the victim who is involved in the situation. Whereas in the order, we see that the orientation of the decision is towards how the accused is working, where he was stopped, what all did he commit and what all did he not commit, which was predominantly what led to deciding whether it was attempt or not. As we know that the concept of degree of determination is what the High Court used, and the Supreme Court commented by saying that there was insensitivity on this regard, bearing in mind the overtone, which is the sexual violence, the sexual abuse which is involved in the offense. Right? They also use terms like they were shocked by the uh, by the language, by the order that has come in, and also that they felt that the tenets of law were not very well were very well interpreted in the particular situation. So comments on certain concepts that were made were also something which the Supreme Court felt that did not align with the kind of crime that had been committed. So it raises a lot of questions. I wanted to show the two perspectives that came in. The High Court, which wanted to take a more technical perspective towards the incident. The Supreme Court may be coming from a place that, bearing in mind the nature of the offense, whether such minute technicalities must be given impetus, or it must also be borne in mind the perspectives which must be taken into consideration from the victim's point of view, the violence, the kind of violence that was involved, and so on. So I hope I leave you with these questions which you must answer based on the different perspectives that I tried to give you on attempt preparation, and the kind of the set of facts that was available to us in this particular case, and whether now does it really culminate to preparation or attempt is something you will have to think over, and whether you believe that you align with the thoughts which came from the High Court or the Supreme Court. Thank you, and I hope you like the video. Please comment on whatever you feel we must be doing in the future. Thank you, students.